Mr. Majeed Memon, you have spent a considerable time of your legal career in dealing with sensational, high profile trials. Can you share your experience from the 1993 blast trial?
Well, I think it is almost 3 decades back that Mumbai experienced serial blasts in 1993, and the investigation went on for more than a year after the investigating agency, both the ATS from Mumbai as also the CBI, because they were parallel investigation, or rather collective, together they were picking up evidence. So the trial in fact began somewhere in 1995, and the trial went on for over 5 years, because there were several unique aspects of this particular trial. It would go down in history as an unprecedented trial with very few, or rather no, precedents, because the number of accused persons who finally faced the trial in a day-to-day trial under the orders of the Honorable Supreme Court, day-to-day trial had to be conducted. A special court had to be set up within the premises of the prison because of security reasons. You see, they were all high security suspects and accused persons. They couldn't be transported from court to the prison every day, and there were so many in numbers that a special court had to be set up where the arrangement was made for conduct of trial. There were more than 100 accused persons in the dock, and therefore a special dock had to be raised within the courtroom, a huge dock which could accommodate more than 100 people who were expected to be present every day to hear the trial, which went on day-to-day basis. We attended the courts almost every day when the trial was going on for years, more than 4 or 5 years. 600 plus witnesses came to be examined, and the trial went on the day-to-day basis for over 5 to 6 years, till the learned trial judge got his judgment delivered, which ran into several thousand pages. Evidence in fact ran into several thousand pages, and in fact when the matter had to be TADA, you see, provisions were such that the trial court's findings could be questioned straight before Supreme Court. The High Court had no jurisdiction. It was removed by statute. So after the trial concluded and the judgment was delivered, and the first appeal, which is a statutory appeal, which was filed by the CBI, the state, or by the accused persons who were convicted, the volume of documents, the exhibits, the evidence, the statement of the accused, was so gigantic that one needed, you see, the whole load of wagon of documents to be brought from Mumbai to Delhi when the Supreme Court had to hear this matter. So there were many special features of this particular trial, a high sensational trial because security threat was there. Mumbai had just come back after the blast to its normal life, and people were still apprehensive about the security, and the state as well as the government, the union government, the CBI, the prosecutors, the lawyers, who were so many in number, there was several features which would make this particular trial different from any other criminal trial.
Mr. Memon, can you also tell us some of your key highlights from the cross-examination and the trial as a whole?
In this particular case, if I recall rightly, there were 2 approvers. Out of those 2 approvers, one was the approver which had given a very long drawn evidence, because he claimed to have participated in every compartment of the crime, because this was a peculiar crime in which there were several compartments. First, the training of the accused persons, for handling of the explosives, etc. That was outside India, and then the transportation of RDX from one place outside Mumbai to Mumbai. Then thirdly, the plantation of explosives at various selected odds areas, 13 places where Mumbai witnessed blasts. And then of course, before that wrecking was done, then the scooters loaded with the RDX were planted by some of the accused persons. So there were different compartments. There were trainings in Dubai or Pakistan as alleged, and then lot many things happened in different areas, and the offense conspiring, then preparing, then actual operation, then after the blast, disappearance of the offenders, their exit. So many things were there. So one of the approver claimed that he had the knowledge of all offenses, all the compartments of the crime from A to Z. He was participant in everything, therefore he was vitally important, and his evidence, in fact played key role in establishing the case as far as the prosecution is concerned. So in that particular evidence of the approver number 2, because approver number 1 was a formal approver, his evidence was not very long, but approver number 2, as I said, spoke about every part of the crime from beginning, from the conspiracy till the actual blast, and thereafter dispersing of the or running away or disappearance of the accused persons or erasing of evidence, etc., etc. So this particular approver's evidence is a memorable, criminal for criminal law students. I think that would be of great educational value also, because you see he is after all an accomplice. There were also certain arguments that how could he be granted pardon if he has committed almost every part of the crime. He couldn't have been pardoned. He was one of the gravest offender, and only in order to prove case against the rest of the accused persons who did not play as important role as the approver himself played. So there was an academic argument that whether a person who has committed the most of the crime or the gravest of the part of the crime, could he be excused? But he was excused, he was pardoned, it was upheld by Supreme Court. The case resulted in conviction of many people, aided by the evidence of this approver. So therefore, there were many things in this case which one could learn, and I had a team of juniors with me who also in fact had enough opportunity to learn criminal law, the method of conducting criminal trial, the method of cross-examining vital witnesses, because it was very important to have cross-examined the approvers and also the investigating officers, because investigating officers had played different roles which were very important in unearthing the crime, in connecting the suspects with the crime, with the offense, and therefore you see the trial was a kind of a source for education of young lawyers and law students.
Amazing.